Thank you very much, Sunny. I hope that everybody can hear and see me. Good afternoon and welcome to our Friday night second online fellowship roundtable series. As you can see, this is a very small and exclusive event. It is a well-anticipated event and it's already the second event of the series. I'd like to thank the AIADR Secretariat and our events team in particular for masterminding this event. As Sunny mentioned, this roundtable series is dedicated to the arbitrators, to the appointment process, and to what considerations in-house counsel and external counsel go through when they make their arbitrator appointment decisions. And given that it's Friday night, you will see that our panelists will have war stories and anecdotes to share on the various appointments and how an arbitrator can salvage an arbitration, but also run it to the ground. As is well known, arbitration is only as good as the arbitrators are. So the second roundtable series is indeed quite important for the dispute resolution arbitration in particular. With that, I'd also like to thank our participants, our fellows. We are very appreciative of your seniority, your experience, and your contributions to the development of the AIADR guide, perhaps later on into the development of this discussion generally. Now, to start the roundtable, I'll first introduce you to our panelists, or I'll introduce our panelists to you, rather. We're truly fortunate to have with us today three very senior members of the arbitration community from around the globe, really. I'll start by introducing Ms. Leonore Riesenberg. She is an independent arbitrator, very well known to most of you. She's also an accredited mediator, so she combines the arbitration and mediation experience. She's been working in the United Arab Emirates since 2007, and she's registered on the arbitration and mediation panels worldwide, including with the leading arbitral institutions, such as the AAC, obviously, but also the ICC, the LCAA, the SAAC, and a number of others in the region. Leonore is truly a female figurehead in arbitration, but she's also, of course, a barrister and solicitor in England and Wales and member of the DAFC Courts of Arbitration and Working Group in DAFC, and also an honorary member of the HAC Global Advisory Board in Hyderabad. So she truly brings a very international experience to our topic here on the arbitrator appointment. Then moving on, we've got Mr. Jeffrey Elkinson, who's with us today. He's a dispute resolution partner with Corners, an offshore law firm. He is probably the only person that I know who is admitted to that many jurisdictions, has rights of audience in that many jurisdictions around the world. He is a barrister in Ireland, England and Wales, and Hong Kong, New South Wales, New York, Eastern Caribbean Supreme Court, Bermuda, US Court of International Trade, and the US Court of Appeals in the Federal Circuit. His practice is obviously commercial litigation and arbitration. So he brings the external counsel experience to the arbitrator appointment process. And importantly, we've got Mr. Zehoi Law, who's based in Singapore and who brings the in-house perspective to the arbitrator appointment process. He currently leads one of Singapore's top well-recognized and well-regarded in-house teams as a vice president, general counsel, and compliance officer for the Aboitiz Food Group. He also sits on the board of directors across gold coins operations in the Asia Pacific region and generally has vast experience in dispute resolution, legal and compliance matters here in Asia and beyond. Now, to echo what Sunny has said earlier, and perhaps given that it's only the second roundtable series of this nature, just by way of a quick reminder, so we'll spend the first 20 to 30 minutes exploring the views and experiences of our panelists. when it comes to arbitrator appointments. And each one of the speakers, is, as I mentioned, has excellent stories to share on that. And then we'll break into several breakout rooms where we'll have more interactive sessions with our fellows. And this is where the fellowship experience really comes to shine, because that's where we learn from you, and there's an exchange of views and experiences that's happening that we're going to record and potentially publish. So with these introductions, getting to the panel, I'd first like to turn to Zehoy, our in-house counsel, with his expertise. Bless you. Sneezing. I just heard somebody's struggling with sneezing. It's Patrick. Patrick, I hope you're doing well. Okay. Yeah. Thanks. So getting back to Zehoy, and I'd like to start with you on the point of actually starting point of where do you begin? You've got an arbitration and you have to appoint an arbitrator. And I appreciate that you probably have the entire team of in-house counsel, but also external counsel to rely on when you make these decisions. But from your in-house counsel perspective, what is the starting point for you? Where do you look for candidates? Do you go through the panels of the arbitral institutions, or do you go to the Global Arbitration Review Arbitrator Know-How website to search for arbitrator candidates, or do you go to specialized databases such as Arbitrator Intelligence or others? Or maybe your decisions are based on something that you would have heard at a conference. Maybe you've seen an arbitrator present her views at a conference and you think that she will be perfect for your case. So how do you make these decisions? What's your starting point? And with all of these complexities that we'll hear about from you, the bottom line is, would you like, as an in-house counsel, would you like to actually get rid of all of these complexities and have some sort of appointing authority that would appoint the entire tribunal on behalf of the parties, just so that you don't have the pain of dealing with all of this?
Yeah, thank you, Olga. I would like to qualify. Most of my experience in arbitration is actually based on the unfortunate events that us as a group have to face. Unfortunately for us, we have actually run a few arbitration cases against a few third parties, and based on those arbitration cases, I think we were quite well equipped. Fortunately, we were well equipped by having a local counsel and also international counsel to advise us. And I think in terms of when it comes to the appointment of arbitrators, we basically relied very heavily on word of mouth from our counsel, external counsel. And I think external counsel, in a sense, bring to the table the sort of experience that they have had when handling other arbitrations with other third parties as well. And from there, we are able to also assess whether a particular arbitrator would kind of have a feel of a certain case in a direction which may benefit your case. So in a sense, when we, just quoting from an example that we had very recently, we had an arbitration in Vietnam. And Vietnam being a jurisdiction where nothing seems to be consistent, we had a case at the Vietnam International Arbitration Center. The first thing we did was we actually got a list of the arbitrators from the website. It was an interesting list because there were a lot of Vietnamese names, and obviously not practicing in Vietnam and not a local in Vietnam, you wouldn't know what sort of expertise these arbitrators actually bring to the table. So we actually ran through that list with external counsel. As part of the conclusion from that, we did not retain anyone from that list, partly also because of the complexity of the case. it really depends on where you're running an arbitration and what sort of issues that you're going to deal with. And sometimes when you go to a country where even the legal process, the legal, what you call that, environment is not to a certain standard, right? You would want to bring in somebody who is foreign, totally foreign from a jurisdiction where they have a much more robust kind of system in place. And that's why, as part of that process, we managed to appoint an arbitrator who is at the same time well versed with civil law, because Vietnam is a country where civil law, I mean, it's a civil law country. So we managed to engage the services of a civil law arbitrator, but at the same time, this particular arbitrator was actually trained in the UK from a common law perspective. So, and that, I mean, it really depends on your case. So for us, we were heavily relying a lot on some of these common law regulations, right, in precedence. So we needed somebody who is from a civil background, who is able to also understand the complexity of applying a common law precedent in a civil law jurisdiction. So we managed to do that. I think this was an institutional kind of arbitration. So the other party also managed to, kind of appoint one of their own arbitrator, and both of them later on subsequently appointed the chairperson who who to our favor was actually part of our initial list as well. So the stars were aligned for us in that sense, like, yeah, so I think that's how we actually managed to appoint our arbitrator for that particular case in Vietnam. I think there are a lot of things that you would like to look into. I mean, if you look into the list of arbitrators, for example, in Vietnam, the VIAC, I think they also have a sort of fee structure, which it's kind of already negotiated with the VIAC. So when you appoint someone from their list, you obviously already have something there. But for us, we tried. I mean, when we appointed our arbitrator, we got our lawyers to do the negotiation, so that at the same time we don't appear as being getting into the wrong side of things as well. You don't want to piss off an arbitrator before your case, right? And I think the first thing which would definitely not put you in a good books is to ask for a 50% discount on your hourly rates, right? I mean, right. that's what in-house counsel do, Part 50% of the time is us asking for 50% reduction in fees.
Yeah.
So yeah.
Well, so Zehu, it's really good to hear, especially from the private practice perspective, that there's a lot of deference to the advice given by external counsel, and that you do rely and seek that sort of advice, and that the lists of arbitral institutions are not necessarily something that is going to be the absolute guiding principle for you to decide on the arbitrator. And I think that's also a very good kind of transition to our second speaker, Jeffrey, who is that external counsel, who, if he was representing you in that arbitration in Vietnam, he would probably also go through the list of available arbitrators and maybe look at publicly available information on other candidates that are not included in that list, and given you that advice. So I'm wondering, and if I may, I'll turn to Jeffrey now. The considerations that you go through, the thought process that you go through as an external counsel when you give advice to your clients, to head legal such as Zehui on the list of candidates that you offer for their consideration. So what do you take into account? Is that as Zehui mentioned, say, civil law, common law divide, or other credentials such as industry expertise, such as pharmaceuticals in that case, for example? Or do you look for, say, do you take into account the diversity considerations? Do you look for female arbitrators? Say, if you end up with a list of perfect candidate arbitrators and they're all male, and do you think, oh, well, I've got to include one woman so that I look politically correct? So what's your thought process when it comes to proposing candidate arbitrators to your clients?
Yeah, thanks, Olga. I suppose all of the above. It's an interesting process because you have the chicken and egg scenario of, is it the lawyer who drives the appointment or is it the client? And so often I find the client already has their views about what they think would be the perfect arbitrator. And of course, for them, the perfect arbitrator is somebody either they know or I know that will decide in their favor. It's an amazing process in the sense that so much of it is all about the will to win. It's all about, we want to win and we want an arbitrator that will decide in our favor. So let's start with that. And of course, then you have to bring them to reality that it's a neutral process. You have an independent and impartial arbitrator, and you have to find somebody, as you said, either very clever in the industry, will understand the nuances, because unpacking all of what you said, Olga, there's a lot there when you think about it. Are you choosing because the person is stupid enough that they'll decide in your favor, or clever enough that they'll work out all the intricacies? Do you choose some sort of politically correct panel? Somebody who's got an amputation even, just to really help disability people. I mean, where does it stop? Where does it start? And for me, towing the straight line is always the best. You want to choose a really good person. And it goes to this topic about, curriculum, putting out the CV. Are you doing it off the CV, or are you doing it from people you know? In the international commercial arbitration field, we're lucky that we have usually great relationships with other people who do the same stuff as us. And either you know them from sitting as an arbitrator, or your counsel and you've seen them in action. You have friends who talk about them, which is always interesting, or conferences. You see people, you meet people at conferences. We have the upcoming AIADR conference this year in Edinburgh, middle of next month. And we'll meet a lot of our old friends, colleagues. I mean, I've been going to AIADR, gosh, too long, since 94, I think was my first one. And it was interesting that you referred to us as senior, because from 94, there are still people who are arbitrators then who are still doing it. And I thought of myself as a kid then. And there's some seriously senior people. And that, of course, has always been an issue about who gets the appointment. Do you go for one of the younger people? Do you use journals, the arbitration intelligence to rely on? Is that what you're going to advise your client? Oh, yes, I've read it in the arbitration intelligence publication. Because, one of the things you have to be careful about is I think it's the term they use in computers, GIGO, garbage in, garbage out. So reading someone's CV, it's like, really? Some of this is really true? I mean, mind you, I want to be clear, mine is true, really, really. But some people, I was looking at one recently, and the person described themselves as an internationally renowned arbitrator. And I'd never heard of this person. I'd be surprised they had more than 2 arbitrations, and they may have only been domestic. But you have to be so careful with CVs. And funnily enough, in thinking about that, when we first circulated about this topic, I looked up about CVs, And I found a great English Court of Appeal decision just from a couple of weeks ago, where this gentleman had lied on his CV and had become head of some division of the National Health Service in England. And the case was about proceeds of crime. And what they were doing was recovering the wages that he had received because he hadn't been truthful on his CV about many of his credentials. And it prompted me to think that if we were to apply that in arbitration matters where, you know, we get this arbitrator and he's not really very good, you know, can we get all our money back, please? Because this is not right. But in fairness to most arbitrators and most people who put themselves forward for appointments, institutions are careful. ICC have a bit more of a pro forma style for CVs. Most people put out their own CVs and it reads well, but how much can you rely on it? At the end of the day, it's all about the individual. Are they a good person? You know, it's the same as judges, I'm sure, in our own experience. At whatever level, you see judges who are qualified to be judges, they're officially appointed, but their temperament is such that it makes them very inappropriate that they should be in such a position. And I've seen it a number of times where just the hidden things, the things that don't go on CV. Health issues is a very interesting one. I mean, you can have a very well qualified person, but they're always suffering some illness or some ailment and they're unavailable and cancellations come in. But, and I can't leave out, because I'm so enjoying it, is brilliant attorney Wu, that you have, I don't know those who've seen the show, it's like #1, but she's autistic and she's Korean and she's the most brilliant lawyer, but her social interactions are really funny. But it doesn't take away from the fact that she's the most brilliant of lawyers. But the autism part is fascinating. And in fairness, I know a lot of clever people who have some degree of it, and it creates funny habits that in the course of an arbitration can give concern to a client. So where do you start to try and answer that question you asked me originally? I think first thing is to find out what the client wants is usually where I start, because without doing that, you can find yourself in a terrible situation as the lawyer. You know, like, why did you pick this guy? You know, we'd never have chosen someone like this. And it is interesting, and clients do know stuff. They do know sometimes very well what they want and what they need. And you start with that, and then you have to either temper their views or give them more input to help them. But there's so many sources available to pick good people. But personally, I like the knowing somebody in some way, either by very, very good recommendation or I've interacted with them at some time.
Jeffrey, on that, there's a lot of excellent questions that have been posed, and I think the clients would have to answer those questions before they make that final decision. And I do notice that both you and Zehoy, we are on the same page, where you say that external counsel has this initial responsibility to put together a credible, decent list of candidate arbitrators, and then the client will make that determination. I'd like to explore a little bit that question of reliability of the CV. And of course, your CV is perfectly accurate and all true to the last letter. But how do you verify their CVs? Do you or your team members, maybe do you schedule appointments with candidate arbitrators? And I know some practices actually do that. And if you do, what issues arise if you schedule that sort of video, maybe appointment or telephone call with a candidate arbitrator who then actually gets appointed? Is there any advice you can give on that?
Oh my gosh, well, I mean, I personally don't really think it's a great idea to do the interview process with potential arbitrators. certainly I know clients like it, and sometimes they'll take on the initiative. And you have professional clients, so they know stuff. In fact, I remember one case where the nominated arbitrator, and he had only been nominated by our side, and the client wanted to speak to them, and the arbitrator just flatly refused. Now, this was before the panel had been constituted. So he had just been their nominated arbitrator. He had been written to, and he was told, we would like to nominate you as our arbitrator in this matter. And what arose from that was, with his very blunt, I can't talk to you, it created the impression that he didn't really know how the process worked. I mean, leaving aside that they wanted to understand his views perhaps on certain matters, or even just to understand him as a person, it comes to who the chair is going to be and giving some input, which is all perfectly proper, as we all know. Until the panel is constituted, you can talk to the nominated arbitrator, nothing wrong with that. But because of his reaction, they immediately started digging to try and get rid of him. And they discovered that his firm many years earlier had acted for their entity, and he hadn't disclosed this. And they went to town, sorry, not their entity, the other side's entity. And it wasn't in the real world in terms of conflict. I would have been reluctant to say it was, but they went to town to get rid of him because they just felt he was not the right person. But in terms of digging into the background and being a policeman and checking the city, I'd be surprised there are too many, if there are any serious practitioners who would go about it that way. I mean, most of us do accept CVs at face value. And that's where it is a very onerous obligation on the person putting out the CV to make sure it's correct.
Yep.
I mean, that's the last thing you want is somebody accusing you of fraud.
Yes, absolutely. And now that that we're on the topic of actual arbitrators, I'm also mindful of time. Although I do feel that we can go on talking about these issues for quite some time. I'd like to turn to Leonora, who brings a wealth of arbitrator experience and has had numerous appointments and sits as arbitrator. And the question that I have for Leonora is sort of moving on past the appointment and into the sort of arbitrator fee negotiation stage. And of course, the question there is, would the choice of a particular arbitrator affect the cost of arbitration? And if so, to what extent? And how, as an arbitrator, do you manage these sorts of negotiations of your fees when you have the scope to do so? Say if it's an ancestral appointment, or if institutional rules allow you to present your hourly rates so that you have the scope to negotiate. So can you haggle with your appointing party, and to what extent do you do so yourself?
Thank you, Olga. First of all, I'd like to thank AIADR for the invitation. I'm really enjoying the discussions. Everybody's bringing a very unique perspective, and I feel really lucky to be the arbitrator commenting here, having heard how difficult a process it is to decide on whose name you're going to put forward, both as in-house counsel and as an external lawyer who's brought in to advise and represent a party. Now, in terms of fees, the first thing I would say is that you don't always have the privilege to negotiate fees. A lot of the time, you're just told how much you're going to charge. And most institutions will tell you what the rate will be. Now, you have the option either to say, yes, I'm happy with that, or you could go in lower. It's very rare that an arbitrator is going to say, well, you're giving me a higher rate, but I'm going to go lower. And it is a Friday afternoon or a Friday evening for most of you. And I certainly have come across one gentleman based in Switzerland that came a lot lower than everybody else. So we have a panel of 3, and one gentleman decided he would be very cost effective. And he certainly made noises along the lines of, I'm very competitive in fee, I'm very cost effective, and that's why I'm taking a lot less. And this gentleman, 6 months into proceedings, decided to resign apropos of nothing. So no one had the courtesy of a phone call, and he suddenly decided to resign. Now you can imagine what other arbitrators around the table thought. He clearly lost interest. He wasn't invested in the proceedings. And I would like to say that experience has a price. And it's not because you pay a certain amount that's going to inform additional costs overall. You could have the right person on board, and I say person, it's irrespective of gender. You can have the right person on board who is going to be more cost effective overall because the process will be more efficient. And you really have to look at all considerations. And it's not just a matter of haggling, of saying, look, take 50% or go and take a hike. Because effectively you might end up with someone who isn't invested and who is disinterested midway through the proceedings, who resigns, or is just dragging their feet and not doing very much. And that's not going to help anyone. You obviously want to make sure you've got a just and fair result and that everybody is invested from all corners of the table. In terms of times when I have had the opportunity to talk fees, that tends to happen on an ad hoc arbitration. And ad hoc arbitrations are very special creatures because, of course, you've got to sit with the parties and discuss the rules and agree the rules and determine rules. And you don't always know what you're getting yourself into until it's further down the road. But I tend to use market rates, and a lot of arbitrators who are experienced will know where the right figure lies, and that would be your starting point. It also depends on the nature of the case, and I'm sure everybody will agree that depending on the case, the value might be less or it might be more. Certainly with large, complicated construction disputes, you would be looking at a larger investment than you would with a very simple, straightforward commercial dispute. So it is relative, and there are quite a number of considerations. I do just want to emphasize, Olga, that there is no real correlation between price and efficiency. And that's the subject that I'm tackling. I'm tackling cost and efficiency and whether there is a link between the two.
Leonor, if I to be the contrarian moderator, I find what you say is very valid and quite interesting, and I agree with you. And I wanted to seek views of Zehoy as an in-house counsel. Say, what role does the fee play in your decision-making process when you're thinking of a candidate arbitrator? Say you've got a very experienced arbitrator who comes in an ad hoc arbitration with a relatively high price tag. And then you've got an arbitrator who is known in the industry, who is somewhat more junior and charges much lower fee, saying that he's very efficient, say similar to the Swiss gentleman. So what's your decision-making process there? Do you go for a higher remunerated arbitrator, hoping for better quality, better experience, better efficiency, or do you not care, given that you're going to pay much more to your external counsel anyway?
Yeah, Olga. I think I mean just based off our last arbitration as well. When we were compiling a list of arbitrators, I think we had a whole list of very qualified arbitrators, and everybody came with a different fee quote. I mean, we were notified by our lawyers that this arbitrator would cost this much, and I think at the end of the day, it's really I think fee at the end of the day plays a part, but it's not the coffin. It's not the nail in the coffin, you know, because at the end of the day, you want somebody who would understand and support your case. I mean, in that case, we were handling a sort of accounting principle kind of thing, you know, in this part of the world, right? If you compare it with places like America, in Europe, they have higher standards of accounting principles as compared to Asia, and not Singapore at least, but in some of the other Southeast Asian countries, there are certain principles which is taken or interpreted differently, even by the ministry and the legal people here. So the thing is, you want somebody who's able to support your case and see, and you know, somebody who's robust enough to try and make a point in whatever ruling later on, right? So we didn't really care much about the price at the end, because as you also mentioned, right, the lawyers are already sucking us dry. Yeah.
Thank you, Teku.
Yeah, Olga, I was just going to add, in the Caribbean, if there's an arbitration here, and I've done one where it was very interesting, the co-arbitrators were down in Jamaica, and I was in Bermuda, and they're very different. They're maybe, 1,800 miles, nearly 2,500, 3,000 kilometers apart. So it's a very different region, but it's called Caribbean. So I was charging 3 times as chairman. My fee rate was 3 times what theirs was. And they said to me when they saw what I was charging, can we charge the same, please? And I said to them, you know, that wouldn't be appropriate. The right thing to do here is to charge your ordinary professional hourly rate. You can't just suddenly get a windfall. And this was ad hoc. So they're asking me as the chair, can we do this? And so my simple answer is no, ethically it's wrong. You must charge your normal professional rate.
I would agree with that, Olga. If I could just interject, I think there is a duty to charge a reasonable amount. So you would not go and see what your colleagues are charging and then hike up the rate. That would not be reasonable by any stretch of the imagination. I'd also like to make a comment about cost, because I am talking about cost and efficiency. That's certainly my question. And there is an aspect that we have overlooked, and that is that often parties, through their conduct, escalate costs. And I've got a couple of more stories that I was hoping to share. I don't know if time allows it, Olga. You'll have to let me know whether I have to limit it to 1 or 2 stories.
Oh, perhaps always time for a good war story, but perhaps maybe one or 2 minutes, and then we'll break into breakout rooms.
Perfect. I'll try to make them shorter in that case. So I've got 2 war stories where parties were behaving in a certain way that was escalating costs, and I thought it might be worthwhile to share it with you all. So the first one was in a very large construction dispute. And this is something that's ongoing. We just had the final hearing recently. And those 2 parties were very, very collaborative, to the point where they were agreeing EOTs all the time. So every single deadline got extended ad nauseum. And it seemed very much like we were proceeding at a funeral pace, and the tribunal was chasing the parties as opposed to the parties chasing the tribunal. So that was quite interesting, and something that I'll let you reflect on, whether parties ought to behave in a certain way that is more cost effective to help the process. The second story, and I am keeping it very short because I am also mindful of time, is that I was also involved in another arbitration, again sitting as an arbitrator with the DIFC-RCIA before it got dismantled. And in that particular case, this is known as an arbitration, which was the largest in terms of the volume of party communications. But on that occasion, we had the opposite. We didn't have collaborative parties. We had parties that were bickering about everything. And every single point, even if it wasn't an issue, became an issue by virtue of the party's conduct. So, you know, it's not just about having the right arbitrator on board, but I think parties and party representatives need to have the right mindset and look at the bigger picture. What are they trying to accomplish? And arguing about every single point or agreeing a new deadline after a new deadline is not going to lend itself to a time-efficient, cost-effective process.
All right. Thank you very much, Leonor. Indeed, that that is the case, and cost efficiency is not necessarily equal to the ultimate amount that would have to be paid. And you need to look at the duration of the proceedings, how the parties behave themselves, whether they're assisting the dispute resolution process or the tribunal, a number of other issues. So with that, we have a wealth of diverse experience in our panel. We have arbitrator experience with Leonora, we've got counsel experience with Jeffrey, and in-house counsel experience with Zehoy, and this is the right time to break into breakout rooms so that we could seek the experience of our fellows, who I'm sure have similar very senior experience on these issues. And I'll call on the AIADR Secretariat to help us break into breakout rooms so we can bring our discussions further.